One of the most controversial and heated questions in Florida, now in the hands of the state Supreme Court. Will voters be the ones to decide abortion rights in the state, or will that decision rest with lawmakers who have currently implemented the most restrictive rules in state history? More than 1.5 million people put signatures on petitions to get this question on the November ballot. The Florida Supreme Court reviews the ballot language to ensure it is single subject and it's clear. Florida's Attorney General filed a challenge to that language, and this week, justices heard oral arguments in this case being watched nationwide. State Senator Lauren Book is one of the most vocal lawmakers in support of abortion rights, and she was right there in the front row of the gallery for the Florida Supreme Court arguments and right here with us this morning via Zoom. Senator Book, great to have you aboard.
Good morning.
Good morning, and thank you so much for being here. So what did we watched these arguments and we saw you in the front row. What did you get a chance to notice that we may not have seen?
Look, I thought that the Supreme Court justices were really right on when they were talking to the state and asking them about their arguments. They peppered both sides with questions. I thought that our attorneys protecting Florida's freedom were far better prepared than the state's attorneys. And I think that they were, while I could never suggest that we would think for the Supreme Court justices, I think that it was a fairly positive day. When you talk about single subject, very clear language, and when the Chief Justice says Floridians aren't stupid, they know what's happening here. And with 1.4, as you said, million Floridians signing petitions to get choice and freedom on the ballot in November, I thought that it was a very positive day.
You know, I'm going to pick up on something you just said. I think a lot of people watching, this is a very conservative court, 5 of the 7 appointed by Governor Ron DeSantis, a pro-life court, as it were. And I think a lot of people we heard were kind of surprised to hear the kind of questioning, especially to your point, from the Chief Justice, who seemed to indicate, tough to read the tea leaves always in these kinds of things, but seemed to indicate that most did find the language pretty clear.
I mean, when you have questions from Curiel and Kennedy, kind of in line with our thoughts and belief in our language, you feel a little bit more positive. When you hear the Chief Justice, you know, while still having some of those very pro-life thoughts, when you're talking about personhood in questions, it does bring a little bit of fear for those who believe in choice. But it was certainly a positive day to hear him say, look, the people of Florida have a right to vote on what this is. If they don't want to support it, then they won't. You know, that is a very positive thing. We'll have the answer by April the 1st, because again, this has to go on the ballot and before the voters in November, and we're certainly hoping that that is the case.
You know, while we talk a little bit, I want to put up, I think we actually have a picture of what would go on the ballot and the language that they were looking at, and this is the actual ballot language. No law shall prohibit, penalize, delay, or restrict abortion before viability or when necessary to protect the patient's health as determined by the patient's health care provider. Essentially, that's the core of it. Incidentally, I'd be really interested to hear from our viewers whether they find that clear, because that is the standard, clear and understandable. But one of the justices, Meredith Sasso, had asked, how do we expect voters to understand clearly what viability may mean with no legal explanation on the ballot of what viability is? Is that valid?
Yeah, and I think Courtney Brewer, who is the attorney arguing on our side, said, you know, these are things that voters are not ignorant to. They understand and know what viability is. And certainly you do more research. Again, that is not, though, the question that is before the court today on that day. It was, is this a single subject? Is this appropriate, and should this be before the voters? And I think ultimately the court will hopefully rule in our favor and give Floridians the ability to have a voice. We know that this is an initiative that is supported not just by Democrats, but by Republicans and independents. In the short amount of time, Glenna, that we were collecting petitions, nobody thought we would be able to reach the benchmarks that we did as quickly as we did, it's because Floridians don't support the extreme agenda that has gone on in Tallahassee that relates to abortion and abortion access.
So what interesting is, to your point, this is not about whether people support abortion rights or not. This is about whether voters in Florida can decide what the law is. And in fact, I want to go back to viability for a second, because viability was at 21 weeks as law prior to the recent restrictions of the last couple of years. Am I getting that right? It was 21 weeks was considered viability?
Correct.
And so
I think that's a moving target, and they talked about that a little
yes.
bit.
And what I was gonna ask you was, viability really does mean different things for different pregnancies depending on health of the mother, or prenatal services, or geography to health care, income possibly. So is viability a clear word?
Look, we believe that it is viable to live outside of the womb. Certainly, that is a moving target. And you did hear some of the Supreme Court justices, I believe was Grosshans, sort of say, where the legislature has come in with a bright line in the sand of 15 weeks, 21 weeks, is that more clear? And again, I think that is a moving target, but I also do think that, again, this measure that we are looking at in front of the Supreme Court is simply to give voters the right and for them to educate themselves before they hit the ballot box in November. And if it's something that they don't support, viability, then they vote against the amendment. But we see increasingly, time and time again with 1.4 million petitions collected, that Floridians support having a right to choose what happens to their healthcare options, right? And I think that we will see that translate come November when this is on the ballot.
In the short time, Senator Book, we have together a little subject switch. You, in the Judiciary Committee this week, you were the sole no vote on a bill going through that would establish no camping rules. This addresses people who are experiencing homelessness, sleeping on the streets, making it illegal to sleep on the streets without permit. And you voted against that. I think your voice is one voice, but it's a very powerful voice, as your family and your dad is so involved and has been so involved in helping people experiencing homelessness as you have. What do you make of that bill, and what are the chances that it will become law?
Look, I think that when you have leadership looking at an issue like homelessness, that is a very important thing. I can't remember a time that we've had both Senate and House leadership looking at an issue like homelessness. I don't know that this is the right way to go when it comes to ending homelessness. Look, the Homeless Trust, Broward County, we have incredible continuums of care here, but that's not the same statewide. And I think that what we need to be getting to is to create a standard throughout the state where continuums of care have benchmarks that they have to meet to chip away at ending homelessness. I don't believe that providing camping grounds and you heard some of my questions that day, where we don't know if there are going to be sex offenders next to children in those areas. What about animals, running water? To provide a camping out area for people who are experiencing homeless really isn't the way that we are going to end homelessness in our state. And then you see other rhetoric. You had the governor that day coming out and saying, don't make Florida San Francisco. That's not what we want to be. We want to end homelessness. There are over 15,000 people experiencing homelessness in the state of Florida, and we know that we can make a difference. The Miami-Dade County Homeless Trust, the Broward County Continuum of Care, we do things differently than we do throughout the state. And I think that providing and allowing for the continuums of care to have a benchmark and move systemically towards ending homelessness is the right way, not necessarily allowing campgrounds where people can be congregated in one area. It doesn't seem like a viable solution. And my no vote really is because I want those sponsors and I want those people to come down to Miami, to come to Broward, to see the work that we're doing to end homelessness. Because
it does sound like that there will be some more detail added to that. And in fact, the governor, when he was talking about it, did mention money for mental health issues and substance abuse issues. So I want to talk more about this on your next appearance here. We are out of time, and I really want to thank you for being with us this Sunday morning.
Thank you. We'll see you soon.
Okay, hope so.